Thank you. And if I may, Chief Justice, in another comment from the Democratic Governance and Rights Unit, they've mentioned that a matter, you were criticised for conduct during the winding up of the Patong travel agency relating to the so-called Travelgate scandal. And they've quoted from a press release where it was said, it is to say the least remarkable that the Secretary to Parliament's attorney, I presume that was you, Mr. Wille, declined to disclose the fact that the resolutions had been prepared for submission by the Secretary to Parliament and its legal advisors. Skippers said, I presume that's Judge Skippers they are quoting. I don't really know what your involvement was in this matter. Can you just clarify?
Yes. First of all, I don't think it was Judge Skippers. I think it was an attorney called Arno Skippers, if I'm not mistaken. But I was part of a legal team. Our leader was Ismail Jamie, SC, who I have a lot of respect for. The legal advisor, senior legal advisor to Parliament was Anthea Gordon and Mr. Dingani, the secretary. What had happened is it was the Travelgate scandal where the travel agency had been liquidated. There was an attempt by the liquidator to collect a lot of money from the members of Parliament. A number of summonses had been issued out. I can't recall, but it was over 200. And expenses were just being run up by the liquidators and there was no recovery. I was called in by Parliament, by Mr. Dingani, to ask whether or not this could, whether we could find a solution to this. I engaged with the liquidators. We had many meetings with them, and we decided to effect a compromise that there would be a payment of so much in the rand. I, together with Ismail Jamie and Anthea Gordon, decided it would be in the interest of justice and would be the best thing to have a creditors meeting because there were other creditors involved. And we didn't want to do this without the other creditors' involvement. We then asked the liquidators to call a creditors' meeting. I was called by the press, and they asked me whether or not, it was someone from the Mail and Guardian, whether we, Parliament, had placed the advertisement. I said, no, we had not placed the advertisement. We didn't place the advertisement. The liquidators placed the advertisement. Anyway, bad press followed. The meeting was scheduled. And because of the bad press, I said to Parliament, let us postpone the meeting for 3 months and let's hear everybody's views. At that stage, Mr. Dingani and myself and Ismail Jamie and Anthea Gordon were taken off the case. The proof of the pudding is really the following. If one looks at what the result was, there was a compromise with the creditors. It wasn't advertised. The other creditors did not know about it. And the claims were bought by Parliament, and at the end of the day, the compromise we wanted to effect happened, but without the knowledge of the other creditors. And if you have a look at the press conference note, which I managed to get from Anthea Gordon last week, and maybe I can just read it to you, the bottom line says, Dingani's legal advisor, Anthea Gordon, told the Mail and Guardian that only one side of the story had been aired. She said that Parliament replied full before the case went back to court in August. So it was one side of the story. I feel that I was misquoted badly. Certainly, I, together with Ismail Jamie, Mr. Dingani, and Anthea Gordon, would certainly not do something which was incorrect or not above board.
Mr. Wille, oh, by the way, not supposed to do the greetings. The follow-up relates to the so-called Travelgate scandal. I know at the time I had the unenviable task of advising some of the members of Parliament. I want to put this to you. Are you satisfied as the legal advisor of Parliament at the time that you did everything to ensure that members of Parliament who were implicated at the time, many of whom were without legal representation to the best of my recollection, were properly advised before they were made to sign acknowledgement of liability agreements? That's the first part. The second part is, can you remind me if in the end, through the intervention amongst others of an attorney who's also a member of parliament that some of those claims were in fact abandoned against some of those members who had initially been implicated?
All I can say is that I relied on Mr. Dingani, who was the secretary at that time, who I felt was a very honourable person. I'm not sure where he is now, and Anthea Gordon, who's still the senior legal advisor to Parliament. What had happened was unfortunate. The liquidators adopted what we, in colloquial terms as lawyers, talk about a shotgun approach. They issued out over 250 summonses against all the members of Parliament. And what had actually happened is the costs associated with that outweighed by far any benefit that was going to be received. And that is why we sought to effect a compromise that the parliamentarians would agree to pay a certain percentage in the rand in respect of their claims. Anthea Gordon and Mr. Dingani sat with all the necessary parliamentarians and explained the process to them. I wasn't involved, and Ishmael Jamie wasn't involved in that process. We were merely involved in advising how we procedurally obtain a compromise by way of percentage in the rand. As to whether or not they were all legally advised, I had to rely in those circumstances on Anthea Gordon and Mr. Ngani, who was the Secretary to Parliament.
And I just want to put it on record that an attempt was made with me as well to pay an amount of just over 200 rands, and out of principle I refused and challenged whoever was responsible for the settlement to issue summons against me and indicate that I would actually defend the matter, because I believed that the manner in which it was handled was unfair to some of the members of Parliament.
If I remember correctly, it now comes back to me that it wasn't a holistic approach. It wasn't an all-in package. That as far as I can remember, the members of Parliament could choose whether or not they wanted to elect to abide by the compromise, or whether they wanted to elect to not abide by the compromise, and then obviously under those circumstances, the liquidators could pursue whatever claims they wanted against them.